Okay, this is the fun part. Now we get to go in more cases, and I love this because it really is interesting and empowering to understand these First Amendment cases because you never know. You never know when you might cite or use one of these cases in your own personal life or personal world. So let's start with Shaq versus the United States in 1990. So what Shaq was doing is he was basically walking around during 1919, during World War One, handing out pamphlets against the war, saying it was a violation against the 13th Amendment, and we're not slaves, and we don't have to serve. They can't have a draft during World War One, and he's arrested for this, and he's arrested for speaking against the war and against the government during a times of war under what's called the Espionage Act. They charge him with espionage, trying to sabotage or disrupt America. Um, and he went all the way up to the Supreme Court, and he claimed that under the First Amendment he could do this. And the Supreme Court said, in times of war, no. And actually, we have a standard that they established. So the Supreme Court established this idea of what's called clear and present danger. If there's a clear and present danger, you cannot use that freedom of speech. It's not covered. So this kind of changed things from freedom of speech as anything goes to freedom of speech as long as there's no clear or present danger, at least is one big aspect of it. So you can't, for example, incite a riot. That would be going back to Czech versus the United States in 1919. And also what it really sets a precedent for is in times of war, we lose a lot of freedom of speech. Or freedom of speech is much more restricted than when it's not during a war, which could be good or bad based on your perspective. But you've seen it with the Patriot Act that people have been arrested for talking or theorizing about being involved in terrorism or other acts. So the idea is that under the Patriot Act, if you're suspected of terrorism, that's not covered under freedom of speech. Which leads into the next one, Gitlow versus New York in 1925. Now, while this wasn't during a time of war, and 1925 was not a time of war, it was very similar. Again, remember back then they would have passed out things on pamphlets. They would have handed them out on the street. And Gitlow is arrested for handing out these pamphlets. But in this pamphlet, he's an anarchist, which means he's against government at all. And he argues that, basically he's leading this idea of maybe overthrowing the government. And that might have to happen through violence. And again, this goes up to the Supreme Court, and they say this meets that test of clear and present danger. You're inciting violence, even in times when it's not war, it is not covered in freedom of speech. So if you're inciting violence when it's not war, still isn't covered in freedom of speech. During war, freedom of speech actually can get more constricted by the executive branch. And the Supreme Court has given these powers to the executive branch and law enforcement at these times. So it does tell you not anything does go according to the Supreme Court when it comes to freedom of speech. The next idea is Tinker versus Des Moines, and this is one of my favorite cases. Mary Beth Tinker, she's up in Iowa, and her and her brother. And the reason I think this is so cool because I actually met her and I've heard her tell the story. And what she said is, she was very socially active in her life early on. She was very aware of that she had friends that were black, and in Iowa at the time, they even had pools where black children weren't allowed to swim. And she and her family were religious, and they were always for social justice. And she said during the Vietnam War, her and her brother and her friend were really upset about the war. So they wanted to protest the Vietnam War. They thought it was wrong that all these people were dying. So what they did is they took these black armbands and they wrapped them around their arms to symbolize their protest against the Vietnam War. And they wore them to school. And she said that the vice principal threw her in his office and was threatening her and telling her, she's suspended. And her and her other friend, Chicken Out, didn't actually do it. So they end up suspending them. She felt very strongly about this. She said this is wrong. So what she did is she went all the way up and got representation and said, no, under freedom of speech, students have freedom of speech, even in public school. And this went all the way to the Supreme Court, and the Supreme Court said, yes, that is true. Students do have freedom of speech for political and religious reasons. So, meaning you could wear a black armband to protest the president or a war or the government. It doesn't cover all speech, but political and religious speech is covered uh, in public school. So that opens up some other discussions to have because I actually had a discussion with her, and I said, well, what about if a kid? Because there was a kid that got in trouble down in one school district. He was wearing a MAGA shirt, "Make America Great," like a pro-Trump shirt to public school. And the teacher or the principal or assistant principal said you can't wear that. It's against school code. And I asked her, well, are you okay with that? Is that covered under freedom of speech? And she said, absolutely. That's political speech. If he's speaking politically, it's covered. Now, we can get into hate speech is different than maybe political speech. That's why people get upset. They're like, well, yeah, but certain kind of political speech could be hate speech. And you get into much more complicated, nuanced, very detailed arguments. But the big idea is that if it's political speech, you guys have a right to it. And also, it goes further. The Supreme Court said it extends to teachers. So, like teachers and people in the public schools, they cannot be fired or lose their job for politically um, expressing their point of view. Now, they could get in trouble for like dictating it to students or trying to teach them, uh, something or something religious. But like, you can't get fired for saying I'm a Christian and you're a teacher, or you can't get fired for saying I voted for Barack Obama or I'm a Democrat or I'm more liberal. That stuff is entitled. You're entitled to that under Tinker versus Des Moines. Mary Beth Tinker. Now, the next one is we're going to talk about in class is National Socialist Party of America in Skokie. And they basically wanted to walk the neo-Nazis, National Socialist Party in the 70s, wanted to have a rally in Skokie, Illinois. And if you know anything about Skokie, Illinois, now it's a pretty affluent area, but at the time it was still an upper-class neighborhood in north of Chicago. And it was a very Jewish neighborhood. And that's exactly what the neo-Nazis wanted to march, and they wanted to give speeches at the public park. And Skokie, Illinois gives you the permits to have rallies at the park, and they said, no, can't have it. So they fought back, and they said, under freedom of speech, though, even though it's hate speech, as long as it's not a clear and present danger of violence, we are entitled to it. And they won. It went all the way to the Supreme Court. And in the end, the Supreme Court let them give their give their speech, even if it was hate speech, but as long as they weren't threatening or targeting an individual. Texas versus Johnson's an interesting case. It's pretty simple, straightforward though. Basically, he burnt a flag upside down, American flag upside down, and there was laws in Texas you can't burn American flags. Still today, there's law. There's restrictions on American flag that you're supposed to burn it at a firehouse, or the Boy Scouts have to take care of it. There's a protocol on how you actually touch the American flag and how it can't touch the ground. It has to be burnt. You can't have a flag staying out at nighttime. There's always supposed to be a light on it. So you have to have a light on the flagpole if you're going to or you have to take it up or down every morning. That's why schools do that. But Johnson said, look, I burnt this flag to say that America, I don't like America, or I need, we're in a state of distress. And this is a form of political speech. And come to find out, Supreme Court said, yeah, that's covered. You can burn an American flag for political speech. So you're seeing the pattern here. Freedom of speech, while political speech and religious speech are really protected, okay? Now, we're going to get back into this drug speech. We're going to find out that's a little different. Morris versus Frederick, and I know a lot of teenagers like this one. Morris versus Frederick is this idea that basically he was a student, and he was actually, I think he was stayed home from school that day, and they had like an outside rally in Alaska, and this kid brought a sign as a joke, and it said "Bong hits for Jesus." I know you guys like that one. It was "Bong hits number 4 Jesus," and he wasn't on the school premise. That's important. He was not standing on school grounds, and he was supposed to be at school, but he wasn't. And the assistant principal walked over. She grabbed the sign, ripped it up, threw it away, suspended him 10 days. It said, you're suspended, don't even come to school kind of thing. And he argued that it was freedom of speech for him to hold a sign that said "Bong hits for Jesus," especially if it was off school grounds. Well, he lost. And this set a big precedent. I know you guys won't like this one, but they said that students are not entitled to freedom of speech about drugs or illegal drugs, because she cited that we have a code in our school district that you can't talk about or have pictures or clothes with illegal drugs on it. And he lost. So, and actually, this has other implications because he wasn't on school grounds when they did this. So it wasn't like they were searching his locker where you don't have a reasonable expectations of privacy at school. While your political speech might be safe at school, your locker and your property has been consensually allowed to the school to search. So we can't bring drug dogs into school and so forth and so on. And you can't wear drug paraphernalia to school. That's not under freedom of speech. But where the bigger thing is he wasn't on the ground. So I want you to think about that, meaning this kid was doing something outside of school, not on school grounds, and they could still give consequences. So you have to think about that opens the door for today. We're dealing with things like Twitter, Facebook, and Instagram, and people are getting on TikTok and they're making fun of each other. And come to find out, because of Boris versus Frederick, schools can have codes and give you consequences. So you can't get suspended or disciplined for bullying or talking bad or attacking students publicly, even though you're not at school because of this case. So actually, Morris's case kind of backfired on him and showed that we do have power to restrict students' speech about drugs and things that hurt people. Now, political speech, Tinker versus Des Moines protects you full-heartedly. So let's look at this one. What is an accurate comparison between Shaq versus the United States in 1919 and Tinker versus Des Moines? Is it A, decide that fight? Well, let's read these. Worlds violate First Amendment, and then decide symbolic speech protected by the First Amendment. Is it B, decide that during times of war, speech can be restricted? And then for Tinker, allowed students to protect the Vietnam War by wearing black armbands? Or was it C, gave Shaq his honorable discharge from the Army? Or suspended students from wearing armbands? Or D, ruled the draft was illegal, ruled the students had rights even in school? Okay. So I want to make sure you guys put B. B as in boys. So you got that? So decided that during times of war, speech can be restricted. Allow students to protect the Vietnam War by wearing black armbands. Those are both true. So during times of war, you can restrict speech, and you can also set this idea of a clear and present danger, because it could present danger to people during war, like sabotage or espionage, and then allow students to protest the Vietnam War by wearing black armbands. You're allowed to wear clothes to protest things. All right. Now let's look at these cases. You got New York. There's some other interesting cases. New York versus Sullivan, very important case. This is actually about Martin Luther King. So Martin Luther King had this big article in the New York Times. And they were talking about how he was mistreated in Alabama. And really, they didn't say the guy's name, Sullivan. But Sullivan knew they were talking about him, okay, in 1964. So what happened in the end is Sullivan sued Martin Luther King, and he won in Alabama. Alabama had some weird libel laws, and he sued Martin Luther, or not Martin Luther King, but the New York Times, the biggest paper in America, for putting stuff in there that could be seen as insulting him. They said they were liable for destroying his character, and we talk about defamation and destroying somebody's integrity or insulting them or lying about them online. That is against the law. Well, the Supreme Court said, and the guy actually won $500,000. Sullivan got $500,000 from the New York Times and won this case. It went all the way up to New York, up to the Supreme Court. They kept going with it, and the Supreme Court said, no. No, you have freedom of press. The press can talk about things as long as they're not producing misinformation or they're not directly lying about somebody. You can't sue them. So actually, Sullivan lost the case, and Alabama's law was against the rules. You couldn't do that. Then it goes to New York Times versus the United States in 1971. This is a very interesting, very, very important case. This is Richard Nixon. So what happens is the Pentagon Papers, which basically show what America has been doing in Vietnam, the executive branch. So remember, we go back last year, we talked about Jackson State protest and the Ohio State, you remember Kent State massacres, where the kids were protesting the bombings in Cambodia and the bombings in other countries around the perimeter of Vietnam. And that came out from the New York Times, and the Washington Post was a part of this too, but they're not in the title. And they start publishing the Pentagon Papers, was showing that the U.S. was doing a lot more things than we knew about. And the president at the time, Richard Nixon, sued and said, you can't do that. That's prior restraint, meaning we don't have to give you all our information as the government if it's for the government to keep us safe. Well, actually, the Supreme Court said, President Nixon, no, you did have to show us the information, that the information was pertinent to citizens' knowledge, and that the president couldn't just, there is no such thing as prior restraint. You can't just hold all information because you want to. And what it led to is people being very knowledgeable of what actually happened in Vietnam, and they didn't like what was happening. Is one of the reasons that the Vietnam fell apart is once the truth came out about how we weren't following the plans and we were adding, the president was doing more than we were told. And it kind of lifted a lot of trust between the public and presidents. I don't know if we've ever regained that much as well. Okay, and then Miller is an interesting one too. So remember, everything's by mail or paper back in the day. So Miller versus California, Miller is basically sending people inappropriate material, like obscene materials, through the mail to people's houses, free. He wasn't charging them, but he was sending them, and he got in trouble for it. And he said that this is covered under freedom of speech. I can send people obscene or inappropriate pornography. Any of that stuff is allowed under the First Amendment. The Supreme Court said, no, that is not true. So obscene or pornography is not covered necessarily under the First Amendment for public use. That you can't put restrictions on it. And that is why, still today that's why you have areas where they allow that and others you don't. It's up to your city or your states. They have different laws and different rules, and you go to different places in America. Some of this stuff you can't even, there's no clubs or anything. In other places it's allowed, and they've kind of made it more of a state power and a local power. And the Supreme Court says you can't do that. It's not covered under freedom of speech. Now, this last case is really cool, and I met her as well, Kathy Colmier. So what she did is these students at Hazelwood East High School up in North County in St. Louis, they wrote an article, and she was the head of the school newspaper with this English teacher, and they did interviews. They did a couple articles where they interviewed pregnant teenage girls at Hazelwood East High School in the 80s. And the kids, they didn't use the students' names, but the kids gave really big details of how hard it was being a mother when you're a teenager, or what it was like being pregnant when you're a teenager. And they were going to publish this in the school newspaper, and they gave it to the principal. And the principal looks at this and he says, no way. He says, nope, you can't publish this stuff. It's going to upset somebody or hurt people's feelings. And the kids felt very passionate that, hey, it's freedom of speech in a newspaper. Why can't we as kids, show these, articles about ourselves and have us talk and do interesting things in articles? And ultimately what the court said is the principal can decide. They can censor, the district and the principal can censor student newspapers and student publications, even in public school. That's not covered under freedom of speech. So there is a lot of restrictions on schools and freedom of speech, but not much on, again, religion and politics are your two types that are. And there's me with both of them. That's me on the left with Mary Beth Tinker, really nice woman, and that's me on the right with Kathy Colmier. And they're both incredibly nice women, and she lives not too far out of St. Louis on the right. I don't know where Mary Beth lives. She's still very political active. They're both very active people that still fight, and they think freedom of speech is really important, even for you guys as teenagers. So we're going to do one more. So freedom of speech press, which of the following principles in the First Amendment were found in New York Times Company versus United States? So let's get these together for the quiz and the test. Was it the guarantee that a reporter could protect the anonymity of sources used in a story? The principle that prior review of a story is allowed by the government? The principle that a newspaper cannot censor even if there are national security concerns? Or D, the principle that there's a clear and present danger the government can't prevent a newspaper from printing a story? And I hope you guys put C as in cat. The principle that a newspaper cannot censor even if there's a national security concerns. So newspapers can publish things. There is no such thing as prior restraint. Unless it's absolute top secret and you can prove without a doubt. But you can't say, after something's happened a lot of times, you can't really use what's called prior restraint. And real quick, you've got those ideas. Let's do another one. See if you guys can get this real quick. Which of the following court decisions is not dealing with First Amendment? Was it Roe versus Wade, New York Times versus Sullivan, Dijon versus Oregon, Dennis versus the United States or Engler versus Vitale, which does not have to do with the First Amendment we've learned about in these videos. And that's Roe versus Wade. Roe versus Wade has to do with the right to privacy, the right to a woman's body, that women have a right to terminate a pregnancy, and they have their own choices. And that case is very important about privacy of your body. The Supreme Court says that is really off the table. The government can't touch your body unless they want to. Even if they want to, that's against everything. So we said again, real quick, prior restraint or government preventing news from being published, can't do it. According to Pentagon Papers, can't do that. That's not allowed. Second thing, shield laws are states that protect journalists from having revealed their sources. You can have what are called shield laws too. In some states, journalists have what's called a right to journalistic integrity, meaning they don't have to give their sources. So they don't have to say, hey, that you are in fact, I know who this guy is. You could say, according to my sources, and that's allowed. And when you go to a newspaper reporter, if you report something, they don't have to reveal their sources. There have been journalists that have many journalists have gone to jail for this. They will not reveal their sources. That's a true journalist, a lot of people would argue. But not all states have these laws. Missouri's kind of in the middle. New York, for example, has a really good shield laws. Like, you really can talk to a journalist and publish things, and they won't reveal their sources under any circumstances. So some really cool things to learn about the First Amendment.